but here's the thing, having a drug problem doesn't excuse you for your responsibilities. So I'm trying to make a decision on whether or not to revoke you and send you to prison or whether or not to send you to treatment. And you're just saying, well, I had a drug problem. You need to tell me something more. What have you been doing with your life?
He had been missing from supervision for months. Then he stood in front of Judge Boyd and tried to explain why. But the explanation did not answer the bigger question. Why did he stop reporting? Why didn't he ask for help sooner? And when Judge Boyd put two very different paths in front of him, the hearing changed fast. This is the moment where responsibility, honesty, and consequences all collide.
Court is calling 2023 CR 7388, State versus Elliot, Scott Veila. Can I have parties announced for the record for the state?
Jason Garahan.
For the defense?
Gary Chirac.
And are you Mr. Veila? Can y'all have the original motion to revoke? All I have is the first amended.
Just a second, Judge, let me see.
But you want to drug court? Oh, okay. It's gonna go to Saturday.
Oh, it's okay, Judge, I'm sorry.
All right. So I thought you were gonna do drug court.
All right, Mr. Veila, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Elliot Scott Veila who was placed on deferred adjudication for the offense of robbery on 2023 CR 7388 for the offense of robbery on November 13th, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
All right, state.
In Bear County, Texas, the defendant Elliot Scott Veila did then and there fail to report the supervision officer as directed for the months of May and June of 2024 in violation of condition number.
How do you plead to that? True or not true?
True, Your Honor.
State waives the remaining violation allegations, Your Honor.
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Judge. He's agreed to go to Saturday.
All right, so how long has he been missing or not reporting? From what year?
The year last year.
I'm sorry?
2024. He does have a drug issue and he's relayed to me that he does want help.
So you've been missing May, June, July, August, September, October, November, December. That's 8 months. All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Elliot Veila.
All right, so you've been missing for close to 8 months. Did you ever call probation?
In the beginning I did, and then I stopped because I figured I had a warrant. I got a letter in the mail for Atascosa County that had a warrant, so that's why I stopped recording.
So why did you never reach out to probation and tell them you need help?
I really wouldn't think I was, like I said, I had a drug problem. I was just out there.
I mean, but here's the thing, having a drug problem doesn't excuse you for your responsibilities. So I'm trying to make a decision on whether or not to revoke you and send you to prison or whether or not to send you to treatment. And you're just saying, well, I had a drug problem. You need to tell me something more. What have you been doing with your life?
Honestly, not much. I mean, I've been on heavy drugs for 15 years now.
I'm sorry, what?
I've been on heavy drugs for like 15 years now, so I mean, it's just been a revolving door, and
Did
I've
you
never
even
had a
do any
program.
of your parenting classes?
Yeah, I completed. That was the first thing I did, and that waived my community service right off the rip. when
All
I
right,
did that.
probation. Did he complete his parenting classes?
Judge, it's a class that
don't have, he completed any of his community service hours.
Well, with the parenting classes, the court said that the community service hours would be deemed satisfied upon completion. All right. Did you do your sober support meetings?
Yes, I was doing those. My PO had a copy of the first few months I was out. Yeah, I did those weekly. She had me doing weekly, but I was doing those.
Did you have employment?
No, not yet, man.
Well, not yet. You've been on probation since 2023. Did you ever have employment since 2023?
I'm just with my mom's boyfriend, her husband.
All right, see, and how's he paying you in cash?
Yeah, so yeah.
I don't do the cash and carry employment here. Do you understand? All right, probation. What are you all recommending?
Judge, the recommendation on the court summary is presided, followed by aftercare. We do need to, tap quality in custody and then for him remaining in custody for the status. I did speak with Mr. Veila briefly, and he did indicate that he has been a long-term drug user, and I would also recommend a felony drug court referral.
All right. So I'm going to give you a choice. You know yourself better than probation knows you, better than your attorney knows you, better than I know you. But these choices come with honesty to yourself. You know, my grandmother would always say, you can be dishonest with other people if that's the way you choose your life, but don't ever be dishonest with yourself. At this point, right now, you cannot successfully complete this probation. You have other things that are going on. So if you would like, I will revoke you. I will sentence you to 3 years, or what's going to end up happening, you're going to remain in custody. They're going to do a TAP evaluation. And I'm going to order felony drug court referral. You're going to remain in custody for that. If felony drug court does not accept you, you are going to be in someone's inpatient treatment. So those are your two choices, 3 years in prison or treatment. Which do you prefer?
And with the 3 years, would I get back time for the time
You see, you receive credit for any time. Legally, I have to give you credit for any time you've been in custody.
And I would discharge my.
No, here's the thing. I don't do this thing where I'm talking to you about what parole is going to do.
Yes.
I can just tell you what the parole law says, but whether or not you're released or not, that's strictly on parole. We can go off the record. Here's the thing. There are certain things that you can listen to inmates about, and it will be true. One, how much time people are actually doing at the prison. An inmate, if they tell you how much time people are actually doing at the prison, usually that's true. Two, when everybody is catching chain, that's usually true. When they're trying to give you legal advice, usually not true. All right, we can go back on the record. What do you prefer?
I'll take the program.
The program, when you say program, what do you mean? Well,
Drug court referral.
it's going to be drug court referral or whatever placement they recommend. Probation has said SATF in this, but if the recommendation is SAFE, that's where you're going. And SAFE is 9 months.
I'll take TC.
He prefers TDC. Thank you for your honesty. It's going to be 3 years prison. Give you credit for any time served. And I'm sorry, are you waiving your right to appeal?
Yes.
All right, 3 years in the prison, give you credit for any time served. There's to be no contact with Nordstrom. And there's also no contact with Adam Trevino. And I'll ask for the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Oh, and I'm sorry, the court is finding you guilty and the court is going to revoke. And I know you understand what I meant, but it has to be on the record. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah. In other words, you don't have, yeah.
This document.
Yeah,
All right. Did you review that with your attorney? Did you understand it?
got a right to appeal, yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Good luck to you. When you are released from prison, you need to take care of your drug habit. Otherwise, you may end up on the side of a street where somebody's trying to identify your body, and I will say, I remember him. So when you are released, if you can't find a place that will help you with your drug addictions, you can always come back to here. If I'm here, I'll pick up the phone, call somebody for you, okay? All right, good luck to you, okay?
All right, good luck.
All right, court is calling 2024 CR 0229, State versus Jesse Ariyaga. Can I have parties announced for the record for the state?
Opinion for the state of Texas.
Defense?
Raymond Martinez.
And are you Jesse Ariyaga?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ariyaga, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
I did. Yes, ma'am.
Counsel, do you waive reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding forward on an amended count 1 of attempted indecency with child by contact.
Any objection?
No, Your Honor.
We will waive count.
Any objection?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did. Yes, ma'am.
Did you understand you're charged? The state is proceeding on the lesser included offense of attempted indecency with its child sexual contact as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain, yes.
I forgot to also include in the amendment, saying we asked that Your Honor read the amendment of also known as the name Jesse Ariyaga. Yes, sir. Excuse me.
All right, any objection?
No, Judge.
And are you Jesus Ariyaga?
Yes, ma'am.
And are you the same person that is listed in the indictment?
Yes, ma'am.
And do you also go by the name Jesse Ariyaga?
Not Jesse R, but Jesse A. Ariyaga.
I'm sorry, Jesse A. Ariyaga.
Yes,
Is
ma'am.
that also you?
Yes, ma'am.
And you're also Jesus Arizola Ariyaga III?
Yes, ma'am.
All right. So did you understand the range of punishment?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record. I see here where you all put state recommends deferred adjudication for a period of 2 years. You all are not allowed to enter into an agreement on the length of probation. So if that's a deal breaker, then
We had an extensive conversation on that, Judge. We understand it's within the court's purview to set the term,
it needs
although
to
I
be
think
removed.
we can still agree to whatever we want to agree to.
All right, so,
And then what I would say is it doesn't bind the court, but
well,
I wanted to have the ability to withdraw my plea if the court was not going to follow that.
no,
recommendation.
you all are not allowed to agree to the term. And it says the state recommends deferred adjudication for a period of 2 years. That shouldn't be here. If y'all want to put down here, this is where your recommendation for 2 years is, but not above the line. So if y'all are trying to bind the court to the length of probation, I'm not going to allow y'all to do that.
That was not the state's intention, Your Honor. Both parties understood that the court has the ability to, and to order however long of probation the court deems appropriate. However, I think defense's concern was that we just wanted it known that our intention was the state was recommending 2 years of
Yeah,
deferred
I mean-
adjudication.
For the court, it's there at the bottom of the line. And if you all want to argue and fight for 2 years on the record, you can, but placing it above the line is not appropriate for the court.
I understand, Judge. I'm not going to quarrel. I understand.
No, no, no.
I mean, I expected you to say something along those lines. However, my position was we wanted to be able to withdraw our plea if the court wasn't going to follow the agreement.
So you all want me to say 2 years, and I'm telling you right now, you all don't get to dictate or make an agreement to the length of his probation if I follow the plea. And I know that's not anyone's intention, but it just should not be above the line. Because this is what's binding upon the
Well,
court.
this is the last thing I'll say about it, Judge, and because I'm not arguing with any of the things you're saying. The issue is, if I make certain representations to my client that induce him to accept a plea agreement, I don't want the rug to be pulled out from under him, because then he winds up with a 10-year probation instead of a 2-year probation. And so I didn't know any other way to address that other than in this fashion.
All right, so this is what I can tell you, sir. The state and the defense are not allowed to present the court and make it binding on the court that I were to give you a probation term of 2 years. They can argue for the length of probation time. They can argue for certain conditions. The only plea bargain agreement you're able to enter into as a binding contract with the state is whether or not they're in agreement to you having deferred. If they agree for you to have deferred, hypothetically, we can go off the record. Hypothetically, if they were to agree for you to have deferred, and then you come to me and I say, I'm not giving you deferred, I'm giving you a conviction, then I have not followed your plea bargain agreement. If they were to say, I want you to have 3 years in prison, and that's your agreement, and then I were to come back and say, I'm not giving you 3 years in prison, I'm accepting your plea and I'm giving you 4, or I'm giving you more than that, I'm not allowed to do that because that's not a part of your plea bargain agreement. The length of time someone is on probation, that's for the court to decide. Whatever conditions, that's for the court to decide. For example, when you hear me telling people you're to report every month, if I were to tell probation they can report once every 6 months, then those are my conditions. And they only have to report once every 6 months. Do you understand?
Yes, ma'am.
So the state and the defense are telling me that they want you to have 2 years probation, the length of time. They can argue for that, but I don't have to give you 2 years. I can look at it. Maybe I will give 2 years. I don't know. I don't know anything about this case. I don't know the facts of the case. I could give you 3 years. I could give you 4 years. I could give you up to 10 years probation. I don't know because I don't know anything about your case. But they can argue and say they want you to only have 2 years deferred. Do you understand?
Yeah.
All right. So if y'all want to step back and discuss that, you can step back to discuss it. If you still want to go forward with your plea bargain agreement, then this, for a period of 2 years, that's initial, need to be removed from above the line.
Well, she might not. Judge, we can scratch it out, Judge.
All right, so if you all want to. All right, we're back on the record. So with regards to the plea bargain agreement, is there any objection from the state or the defense, thank you, to the court removing the words for a period of 2 years next to the state recommends deferred adjudication?
Objection from the state.
We do not, Judge.
All right, so the court will remove that portion. And Mr. Ariyaga, do you have any objection to the court removing that?
No, I don't.
All right. So you understand the range of punishment?
I do.
And you understand that if you have a plea bargain agreement, the court does not have to follow your plea.
I do.
If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. Do you understand?
Yes, ma'am.
By entering this plea, you are giving up those rights. Do you understand?
Yes, ma'am.
Do you understand? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Ariyaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense under count 1 of attempted indecency with a child by contact. There's a $1,500 fine. The state is recommending deferred adjudication. There's to be Chapter 62 compliance. And of course, you know, there is a registration period related to that of 10 years. And there is to be no contact with the complainant. Do you understand?
Yes, ma'am.
Do you understand that to be the entirety of your plea bargain agreement? Defense is at the plea?
It is, Judge.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I do.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years and that you be with the sex offender unit. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This time, State Officer 6, Exhibit 1 with all attachments.
No objection, Judge.
All right, and state, have you spoken to the complainant or the complainant's family?
We have, Your Honor.
All right, thank you. You may be excused.
Your Honor.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Counsel, I'm sorry, I don't see it in the stipulations, but did your client ever talk to the police or did they ever contact him?
They contacted him. I don't think he ever got a statement. Right. Yes.
So I'm just checking to see if that's in any of the
There's
states
no
and I don't see
admissions,
any.
no, Judge.
I'm sorry.
There's no admissions or statement. No.
Okay. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court would defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to, judges.
Anything you wish to say on behalf of your client?
Judge, all I can say is that, as you can see from the nature of the plea bargain, there was a lot of exchanging between the parties of information, mitigation, the history of the case, the issues with the child. Unfortunately, she had a very difficult upbringing, losing a parent very young and didn't have the other parent. It just goes on and on. We went through CPS records, we went through counseling records, and it was a hard decision for Mr. Ariyaga to arrive at, but he felt it was in the best interest of himself that he not expose himself to a different kind of an outcome. And he's going to have an extensive registration, which doesn't begin until after the term of probation expires, which is why we had such a long discussion about how long his probation was going to be for. He has a clean record for the most part. He's been gainfully employed. He's never missed court, never been late to court, has not had any violation reports. He's ready to put this case behind him. We do want to address one issue regarding his ability to have access to his grandchildren. Because of the nature of the case, obviously there are restrictions in that regard. The parent of those children is here in court. If the court needed to hear from him or he could advise probation in writing what his desires are in that regard. He's not asking for unsupervised. He just wants to be able to see him as he has been their whole lives. Other than that, Judge, we've asked the court to follow the plea agreement.
All right, this is what the court is going to do. Is there anything you wish to say?
No,
All right, and what do you do for employment? Not where you work, but what do you do?
I'm a barber.
All right. This is what the court is going to do is a $1,500 fine, time and money, I'm sorry, $1,500 fine probated. Chapter 62 registration. There's to be no contact with the complainant. Regular reporting by Zoom or in person. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular and random UAs. With the UAs, you can either do a patch. The patch costs more, but you won't have to, it's less time constraints on you. There's to be no unsupervised contact with minors. If he's to have a contact with minor, it'll have to be an approved chaperone by probation. And usually, for example, with regards to your grandchildren, you'll need that person to be the supervised chaperone. Usually it's approved. If it's not approved or there's something with that, just let the court know.
Understood.
And he'll be with the sex offender unit, and the court is going to sentence you to 4 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you. Thank you. Probation will go over conditions.
These hearings show how Judge Boyd handles courtroom responsibility from two different angles. In the first case, the issue was missed reporting and whether the defendant could honestly choose the structure he needed. Judge Boyd did not let the explanation carry the whole hearing. She made him face the decision directly. In the second case, the issue was control over the plea terms. Boyd made it clear that recommendations are not the same as court orders, and the final conditions belong to the bench. That is what makes these hearings powerful. The outcome is not built on sympathy alone. It is built on the record, the choices, and the conditions Judge Boyd believes are necessary. Comment which moment carried more weight, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.